right, the next case to come before the court is in re CW and BW. Mr. English, you're the appellant here. You will have 15 minutes to make your argument. Let me know if you want to reserve time for rebuttal. I'll do my best to monitor that. To be obvious by the title, please don't refer to any of your children by name in this matter. We have read your briefs and we are ready to begin with one.
Thank you. May it please the court. Again, my name is Brent English. Your Honor, I would like to reserve 4 minutes of my time.
All right.
Thank you. Your Honors, we are back on this case. I meant to count up the total number of appeals that have arisen from in respect to these two parties and in respect to these two children. I believe the number is 13. This is one of 2 appeals that my clients, Melva and Scott Sherwood, have filed over the period of time in this case. This appeal concerns one specific issue, and that is whether or not this court intended, and when it issued its decision in re CW and BW in 2018 at the end of the year, to conclude that the trial court never had any jurisdiction to do anything in this case beginning in November of 2011. That issue was specifically raised by the appellant in re CW and BW, the appellant being Lindsay Eberhardt. And this court specifically found in its decision in 2018 that her assignment of error on that issue was not well taken and was denied. Nevertheless, after this case was remanded, there were 2 issues that were present with the trial court, and the case was remanded for proceedings consistent with this court's judgment. That's the nature of the remand that was made. One issue related to contempt proceedings that had been brought against Lindsay Eberhardt for violating a court order that was issued in 2011 and a subsequent order that was issued in 2016, which was reversed. There's no dispute about that. In 2011, the parties reached an agreement on the record. That is to say, both parties in front of the court with a court reporter present, that Melva and Scott Sherwood, or the grandparents of these 2 children, would have certain grandparent visitation with these 2 children. That occurred in October of 2011. Then a final judgment entry was memorialized by then Judge David Baczynski on November 1st of 2011, which memorialized the settlement that had been made and made a determination that that grandparent visitation would proceed.
Was that settlement agreement that the parties reached at that time voluntarily, did the Sherwoods at that time agree to dismiss their complaint for dependency?
There was no complaint for dependency.
Isn't that what they initially filed this whole thing under, a complaint for dependency under 2151?
Well, it was a 2151 filing, that you are correct about that. But, Your Honor, it was my understanding it was basically an in re paralis kind of complaint that had been originally filed, and yes, the answer to that is
But it wasn't a
yes.
complaint for legal custody, it was a complaint
No,
alleging
ma'am.
dependency and neglect, and they asked for legal custody.
If you're telling me you have familiarized yourself with what had been filed in 2010, and
That's what I'm asking, what was the original complaint in this case that precipitated the settlement agreement?
it is my understanding that it was a complaint for legal custody. It was not specifically alleged to be a private dependency case.
Okay, so it was a complaint for legal custody, and they agreed to dismiss their motion for legal custody in exchange for getting visitation rights with the grandchildren.
Precisely correct.
Okay, and if the complaint was dismissed, and the resolution was we have visitation, how could there be anything subsequent to that if the complaint was dismissed with disagreement on the record?
Well, because it is a judgment entry, when parties reach a settlement in a case, it is clearly enforceable by a trial court.
Okay, and if the court is going to enforce it, then what's the remedy that the party has that's seeking to enforce it?
It has a contempt remedy. And there is a court order granting grandparent visitation that was in place for an extended period of time.
Okay, you're saying this is a court order, but in actuality, it was a settlement agreement that was put on it. It was a settlement agreement that the parties reached.
It was a settlement agreement that was then memorialized into a court order. And this happens all the time for very valid reasons. Judge Basinski put a judgment entry on. It is hereby ordered, the judge and decree, based upon the settlement of the parties as follows, and set forth what the grandparent visitation was. And when there was a challenge to whether or not the court had any jurisdiction to do that, this court specifically held in In Re CW and BW that challenge to jurisdiction was invalid. The issue in Re CW and BW was a subsequent judgment entry that was entered by Judge Janik, the trial judge at the time, where he attempted to modify the terms of the settlement agreement itself. And this court held that that was improper because jurisdiction had never been properly invoked with respect to that motion. So what was pending in front of the court at the time of this judgment, which dismissed everything that was pending, was the contempt proceeding and a subsequent action that was brought and properly served and properly brought under the relevant statute for grandparent visitation when a parent is deceased.
Was a complaint ever filed by the Sherwoods alleging that their son was deceased and they're seeking grandparents' rights because their son had been deceased and now?
Yes.
There was a complaint filed for that, or there was a motion filed in the original?
It was dubbed a complaint. It was given the same case number.
Same case number, on a
Correct.
dismissed complaint.
Correct. Well, it was given the same case number on an existing case that there had been a judgment entry on that the parties had been operating under. That happened in June of 2018. That motion was pending. Motion/complaint was pending at the time of this court's judgment. Then there was an amended complaint that was filed, again in that same case number. And after this court, after the trial court decided that it had no jurisdiction whatsoever to entertain that motion or the contempt proceedings, then a new complaint was filed, which is not part of this record, but I'm just telling you that there's a new complaint that was brought under a different case number seeking the exact same relief. The issue in this case is whether this court intended to say that, and in fact did say, that it did not have any, that the trial court had no jurisdiction to do anything in the prior case number. And as to that, I respectfully submit the trial court got it wrong. That there is jurisdiction to enforce a court order that is entered on the basis of settlement. There is no doubt about that. And if this court were to hold that parties can enter into a settlement agreement that's memorialized by the court, and then 4 or 5 years later, a party can repudiate that settlement agreement without consequence whatsoever, we have changed the law.
But wasn't part of the agreement that parties agreed that before they came back to the court, they'd have to mediate whatever disagreements they had, and wasn't that followed?
Actually, two things. No, there was no agreement about that. There was an agreement that there would be a mediation that could be followed, and I cited that in my reply brief because this red herring was raised by the appellees in their brief. And furthermore, the record is clear that mediation was attempted. So, even if mediation was required, we complied, and mediation was not required in any of that. So this issue really is a pure jurisdictional issue, and it is also an interpretation of what this court intended in Re CW/BW, which I've read that decision many times. I of course do not like the decision, but irrespective of that, I understand the court's decision, and that issue related to the 2016 judgment entry that Judge Jenny put on, and this has been misconstrued by the appellees, and I believe it was misconstrued by the trial court in this court, or in this case, to hold that there was no jurisdiction, period, as a result of a settlement that was memorialized into a judgment entry. If we cannot enforce such a judgment entry, then no party will ever enter into a settlement, particularly on the record where there's no dispute about what the terms were, because that judgment entry doesn't mean anything. That is functionally what the appellee is trying to say in this case. That no matter what we agreed to, no matter how clear it was, no matter that there are no disputes about the terms, that at some point we can simply repudiate it with impunity, and there is no jurisdiction to do anything about it.
In this case.
Well, what other case would there be an opportunity to do anything about it?
Well, you said that there was another case that had been filed, another complaint that was filed under a new case number.
That's correct, because
So
the issue...
enforcing the visitation couldn't be something that would be presented in that case?
Yes, except the trial court in that case determined that it was going to stay proceedings in that case, while it waits for this court to tell it whether it got it right or whether it got it wrong. And in the meantime, these kids are growing up, and the grandparents have no contact with their grandkids, and that in itself is a tragedy. And so we appreciate that the fact that this court set this oral argument quickly. That was important to us. It's really important, I think, to clarify what the court intended in CW and PW, and it doesn't matter whether we file another case to try to work around the judgment of the trial court in this case. The fact of the matter was there was jurisdiction to proceed, and the trial court improperly dismissed this case, and as a result, I ask you to reverse. I'll reserve the remainder of my time.
You're only 5 seconds under your 4 minutes, so very good.
Thank you. And my name is Jonathan Rosenbaum. It's my honor to appear before you on behalf of Lindsay Everhart. I want to point out that the misconstruction of this case was not by myself or the trial court. It's Mr. English's interpretation of what this court ruled. Judge Boros decided, it clearly stated, that based upon this court's decision, the agreement, the entry of November 1st of 2011 was unenforceable. And she was correct, given the remand that she received. The misconstruction on behalf of the Sherwoods takes place because they intentionally and wrongfully claim that when the trial court overruled Everhart's assignment of error, that the trial court lacked jurisdiction to issue the November 1st, 2011 entry, that somehow implies that jurisdiction existed. That question was never answered or reached. This court ruled that it was not an exercise of jurisdiction when the judge approved that agreed settlement entry. And finding the issuance of the November 1st, 2011 entry was not an exercise of jurisdiction is not the same as finding that jurisdiction existed. And that's the flaw in his argument. He wants to argue the converse, not what really happened. This court has held that that was not a judgment entry, and that the trial court's efforts to raise it to a judgment entry were error. This court said that the trial court transformed a voluntary agreed visitation schedule into a judgment granting the Sherwoods a right to visitation and establishing a visitation schedule, and it correctly reasoned. The Sherwoods begged this issue on page 4 of the reply brief when they claim it cannot logically be argued that the November 1st, 2011 entry was something other than a judgment. That's exactly what I'm saying, and that's exactly what this court held. The court is correct. If anything's to be done in this case, it has to be filed under a new case number. The lack of jurisdiction or the failure to exercise jurisdiction cannot give rise to a judgment which permits them to proceed under Juvenile Rule 35 as if there were an existing judgment. Judge Boros correctly followed the mandate of this court and refused to enforce this entry as she was required to do. Secondly, Mr. English is arguing that this entry, which was found not to be a judgment, is a settlement agreement that can be enforced. And he cites and acknowledges on page 6 of his brief that this is a contract principle. However, contract law is clear, as Judge Schaefer has intimated already today, that you have to comply with the agreement before you can come to court and assert a breach. There was no attempt at mediation. The record is not clear that mediation was attempted in this case, as Mr. English has just represented. And as a result of that, the Sherwoods cannot come to court and argue or try to assert an agreement that they have not complied with.
Was mediation required, or was it optional in the agreement?
No, it said that the parties would go to mediation if any disputes arose, and then it also gave the right to the children, upon reaching, I think, the age of 10, to say they don't want to go anymore, and just inform the mediator, we're done with this visitation.
Now, Mr. English said mediation was attempted.
I believe that is incorrect.
You can't
There was no
agree, the
mediation.
two of you can't agree whether or not mediation in this
No
case was
mediation,
attempted
and
or not?
The record is clear that Mrs. Sherwood was examined on whether or not, when Lindsay Everhart reached out to her and said, you're not living up to the agreement, you're violating my rights as a parent, I don't want you to do these things, that she just basically blew her off. There was no mediation, and to reach out to attempt to resolve this prior to formal mediation was admittedly rejected by Mrs. Sherwood. That's in the record. And to meet this argument previously, Mr. English describes it as ludicrous and laughable. At this stage, in this appeal, it's now merely a red herring. But my brief is replete with law that requires them to meet these prerequisites before they can assert this contract in court, if, assuming it is an enforceable judgment, which this court has said it's not. And I think what this court was driving at in its prior decision is that this voluntary settlement agreement does not usurp Lindsay Everhart's fundamental rights as a parent to decide what's in the best interest of her children. And until there is a finding by a court that visitation with the grandparents properly filed and sought would be in the best interest, or that my client is somehow unsuitable, it's up to her.
So is it your contention then that the settlement agreement is not enforceable at all?
Correct. And I believe that their remedy would be to come back to court under a different case number and comply with the prerequisites to file the proper complaints to get grandparent visitation, or a complaint to prove that my client is unsuitable, and then reach the second issue of whether or not it would be in the best interest of these children to do something different.
Was the complaint filed by the Sherwoods after the decedent passed, where they sought grandparent visitation rights? Was that after the settlement agreement?
No. Well, it depends on which one you're talking about, Your Honor. There have been like,
But let me ask this then, was a complaint, do you agree that a complaint was filed by the Sherwoods after the decedent passed, seeking grandparent visitation rights and visitation?
I
Was there one
know that a
filed?
complaint was filed seeking custody. There was no complaint filed seeking grandparent visitation. And that was, I believe, the basis for your ruling that the entry previously was void. Now, subsequent to that, they have tried to remedy this situation by filing and refiling. And they keep trying to refile, asserting the November 1st, 2011 entry is a judgment that gives them, they can invoke the jurisdiction to carry that out. That can't be done. It's my belief, if they're gonna do anything, they have to start anew with a new case number, with a verified complaint, as the rules require, and they may have finally done that on their last attempt. Prior to these things being done, when what concerns us before this court, nothing was done properly.
All right, thank you. 3 minutes and 54 seconds.
Okay, let me clear up this confusion. In 2010, Andrew Weaver, the father of these children, was alive. The initial complaint sought legal custody, not on the basis of dependency, but on the basis that the parents were unsuitable at that point in time, under the formulation of in rem provisos. Then, while that case was pending, the grandparents sought alternatively grandparent visitation. And then the case was settled, effective November 1st of 2011, granting the grandparents grandparent visitation.
And that was under mother being an unmarried woman.
No, there is a variation. Lindsay Eberhardt and Andrew Weaver got married during the pendency of the case. So at the point in time when the November 1st entry went on, parents were alive and they were married. Then nothing happened. Andrew Weaver unfortunately passed away in October of 2013, I believe. And then following that, the Sherwoods filed a motion to increase grandparent visitation. That was the issue in re CW and BW. Then when Lindsay Eberhardt decided on her own to terminate all grandparent visitation despite the terms of the November 1st settlement agreement, there were 3 separate motions to show cause that were filed for each month where the visitation was being denied, which the trial court then adjudicated, found that she was in contempt, found that she had no basis to violate that order, and held her in contempt for violating not only the November 1st entry, but also the subsequent entry, which this court ultimately invalidated. So that issue was still pending in front of the trial court at the point when the trial judge who was assigned to this case now, Judge Janik recused himself, determined that there had been no jurisdiction to enforce the terms of the settlement agreement itself. And I appreciate Mr. Rosenbaum's great advocacy on behalf of Lindsay Eberhardt, but he is flatly wrong. I don't mean to say this personally to you, Mr. Rosenbaum. But if you cannot enforce a judgment entry that the parties entered into in front of the court and that the court memorialized as a judgment entry of the court, then we are in trouble. Because all day long in domestic relations courts and every other court, we enter into settlement agreements and we expect them to be enforced, and there are abundant cases in this district and every other district holding that a court has jurisdiction to enforce a settlement. Period.
But doesn't the court have to have jurisdiction over the subject matter of the settlement before it's a valid settlement?
It did have jurisdiction over the subject matter. Whereas I said, if there was an action filed for legal custody, and then there was a subsequent motion for additional relief, it had jurisdiction.
Did the court actually ever have a formal trial, a legal custody trial?
It did not. The matter was settled.
So it was a settlement. So the court never actually heard anything about the best interest of the children or anything under legal custody in Retralis standard.
That's correct, because the parties settled the matter. And let me just point out one more thing before my time runs out. This idea that somehow we didn't mediate, I think this is hard to understand. I just asked the court to look at the record entries 100, 101, and 102, which should put that issue to rest. And I know Mr. Rosenbaum was not counsel for Mrs. Eberhardt at the time. Perhaps he's not knowledgeable about the facts, but those are the facts. So I would respectfully ask the court to reverse and remand with the specific instructions to this trial court so we do not have appeal number 14. Thank you.
All right, gentlemen, thank you very much for excellent arguments on behalf of your clients. We will take the matter under advisement, issue a written decision in due course. It will be mailed to both sides, posted on our own website and that of the Supreme Court. This court will next